When I was in law school, I studied the Uniform Commercial Code, which is the body of law which, well, among other things, uh, covers the law of debtor-creditor relations, the relationships between people who owe money and, well, basically their banks or any lender, factoring companies, whatever. But the law of borrowing and lending. Although it was the Uniform Commercial Code, the UCC, we witty law students called it the BAW, Bank Always Wins, because that is what the UCC says. Bank always wins. In fact, the bulk of the UCC is not about debtors and creditors at all, but how to resolve conflicts among banks when there's no issue. But the banks win, we're going to wipe out the debtor, but there's not enough money to go around among them. There is almost no concern whatsoever in the UCC for debtors. There is a doctrine in there of unconscionability. If the terms of a contract are, actually, now I think about it, that might not be in the UCC. That might be a common law concept. But if the terms of a contract are so just horrible that it just shocks the conscience, that it's unconscionable, the law may provide a remedy for the debtor. But beyond that, there's just no help for debtors. Once you're down, that's where you stay. And that really is the way our law is structured. I had a client come to me once. She gave me her Citi card bill. And I noticed on there that she was paying 30% interest. But I also noticed that her finance charge, her interest charge, was just one of a number of charges, and that she had two others that were just as big, one for being over the limit, the other, I think, for being late. And so I got out my calculator, and when I figured it out, she was paying 98% interest. So basically what that meant was she could pay 100% of what's in each monthly statement for a year. And at the end of the year, she would pay the equivalent of what she owes, but still owe what she owed at the beginning of the year. Our law is designed to kick you when you're down. It just is. If you're not creditworthy, your credit card companies do get to increase your interest rate. Here in Massachusetts, our usury laws are not consumer protection laws. Our usury laws are anti-organized crime laws. In other words, our usury statute makes it illegal to charge more than 20% interest, unless you tell the Attorney General you're going to charge more than 20% interest and keep books and records that the Attorney General may inspect. The thinking there, of course, is that the mob doesn't register at the Attorney General and doesn't make their books and records available to the Attorney General. So usury statutes can be used to go after organized crime. But Citibank keeps books and records, and Citibank registers with the Attorney General. Citibank's not the mob. They're not the mob. So the usury statutes do not protect you from them. In a system in which bank always wins, in a system in which that kicks you when you're down, in a system that says once you're down, that's where you stay, there needs to be some manner of a relief valve. There needs to be some way to let off pressure. There needs to be some way of taking care of the people who are so crushed, so oppressed, so put down by their debt that by their own devices, they will never get back up. And thus, there is no reason for them even to try. They have no reason to get out of bed. They have no reason to go to work because all their money is going to their creditors. That safety valve, that pressure release, that protection for people who are so crushed and overburdened is the bankruptcy code. The bankruptcy code is an act of Congress. It's Title 11 of the United States Code. It puts in very specific, very broad, very powerful protections for people who are seriously in debt. It gives great power to bankruptcy judges and by extension to bankruptcy lawyers. In the course of my career, I have knocked off millions, probably tens of millions of dollars, but certainly millions of dollars of Citibank debt, of Bank of America debt, of JP Morgan Chase debt. And I've done it while saving hundreds of homes, thousands of vehicles, hundreds, if not thousands, of 401k plans, IRAs, retirement plans in general. In many cases, giving up nothing. It's very powerful. I like to say that that the big banks are afraid to come to bankruptcy court and fight with me. I like to think they're afraid of me, but actually it's the law. There's really no point for them to come in. They're going to lose. Actually, there was a pretty wild decision just this past week or last week, I guess, by Judge Hoffman, currently the chief judge of the bankruptcy court. It was a lawyer. She was coming after her divorce client who really did her dirty. I mean, Judge Hoffman was very unkind to the debtor in terms of describing how ugly her antics were, in terms of how she treated her lawyer and pretty much swindled, or all but swindled, I guess. And I guess that's the key, all but swindled her lawyer, but declared the debt, but discharged the debt anyway. The bar to getting, to defend, to a creditor defending themselves in bankruptcy is very high, because the whole point of bankruptcy is to wipe the slate clean. The whole point of bankruptcy is to give the debtor a fresh start. And that's what bankruptcy does. It's powerful, and people need to, and I hope that this video helps people to understand that it is a good system. It is an important system. In fact, it's actually enshrined in our Constitution. And it's not something that people should be afraid of or ashamed of or resent. It is part of the very fabric of our being as a country and as an economy. And it is part of what makes us who we are and keeps everything working in a system which really, by necessity, otherwise, the bank always wins. Thank you.